Hi everyone, this is Mohammed Akram. We are here to discuss the FINCEN beneficial ownership reporting requirements under the new law. I have a great panel with me, which they will introduce in a bit. But before we proceed, I want to cover some housekeeping items. And any attendees who wants to get the CPE certificate have to answer 3 out of 4 polling questions, and we will send them the CPE certificate within the next few days. So let's continue the conversation, right? Again, my name is Mohammed Akram. I'm the founder of Akram Insurance Advisory and Tax Firm. Sorry. We provide the accounting, audit, and tax services to hedge funds, private equity, venture capital, and family offices. Simon, please make an intro.
Yeah, hi everyone. This is Simon Rivlis. Rivlis Wahab is our firm. We help fund managers launch and provide ongoing advice to investment managers of all kinds. I'm here with my colleague Matt Hofferholick, who can introduce himself as well.
Sure. Yep. Hello, everyone. I'm a colleague of Simon's and had a fair amount of experience in forming funds and working on other corporate matters for the past few years, and excited to be here.
Thank you. Dan?
Great, thanks. So as you can all see, I'm the only one who's not wearing a blue shirt, so it means I'm probably not professional. I'm with ANC Advisors, and through our sister company, ANC Corporate Services, we are actively filing BOI reports on behalf of entities all over the country. And our experience in this area has been to really take the bull by the horns and make sure that we get the right filings, the right information to get the right filings done in the right amount of time. ANC, as many of you probably know, has been around for about 24 years, and 23 years rather, and we work with fund managers, broker dealers across the world to help them with strategic advice and counsel.
Thank you, Ken. Let's start the conversation, and we have a lot of ground to cover. I would start with Matt, right? If you can give us a brief overview of CTA, Corporate Transparency Act, and why this act is necessary and how it's going to impact our clients, which are in the financial services, hedge funds, private equity. Please, Matt.
For sure. So as you all know, the Corporate Transparency Act is passed primarily to ensure the efficient fighting of financial crimes, ensure that all investors feel safe in having their money, their funds parked in certain entities, that managers, are not, are who they say they are, and that they are making sure that the funds are being used for their proper purposes, as well as just companies in general, because obviously this act applies not only to funds, but also to potentially millions or even tens of millions of entities going forward in the future. As part of the efforts made by the Corporate Transparency Act, all entities, including most people on this call, will have to file a beneficial ownership report with the United States Department of Treasury's Financial Crime Enforcement Network, or FINCEN. Most of these entities, there are some exemptions for these requirements, including SEC registered investment advisors and the funds they manage, but for the most part, if you are not an SEC registered investment advisor, you will have to report all entities within the fund ownership structure. That includes the general partner, the investment manager, and the fund, including whether you are an exempt reporting advisor with the state or the SEC, or a registered investment advisor with the state. Again, the only ones that are exempt would be SEC RIAs or venture capital fund advisors. If you think you fall under that exemption, please, contact us or contact someone else with expertise on this. In terms of the actual reports to be filed, and I think we'll go into this later, The information is pretty basic, full legal name, any trade name, US address, state of formation. I think Simon will go into who is a beneficial owner, as well as company applicants. And this is a important point which we'll go into. The deadline for doing this is if you are formed before January 1st, 2024, you'll have until December 31st, 2024 in order to file. If you're formed after or on January 1st, 2024, you will have 90 days to file within the first year, but 30 days if you are formed after January 1st, 2025, which, not so relevant for now. And if you are formed, again, we'll go into this all after, trying to provide more of a high-level summary. Company applicants as well, which are essentially the lawyer, anyone forming this company will, if you are formed on or after January 1st, 2024, you'll have to report those as well. We'll dive into the details later, but I think that provides a pretty high-level summary of the important points there. And maybe one more point to mention is that if any information changes, you'll have 30 days to file, which is kind of a short period of time, but that's what the law says. I think other than that, I think it serves a high-level summary of requirements imposed by the CTA.
Okay. Thank you, Matt. Simon, would you please tell us that which states are going to introduce the similar laws, and are there any big differences between them?
So right now, in terms of the states that have adopted their own beneficial ownership reporting requirements, New York is one that we're most focused on being based here in New York. Those rules go into effect beginning of 2026. So they're giving us some time to prepare, but that will be applicable. Well, any LLC formed in New York or authorized to do business in New York. One of the notable differences between New York and the federal FinCEN requirements is that in New York it only applies to LLCs, whereas the CTA, the FinCEN rules applies to any company. California has also adopted some form of these rules, but we don't know of any other states at the moment that have at least passed them. I can we'll look into that and to see what other states are proposing to adopt some of these rules. I can also add to Matt's summary that a beneficial owner for purposes of these rules under the FinCEN guidelines, and also these are been implemented in New York, is a beneficial owner is an individual who exercises either directly or indirectly substantial control over the reporting company, or any person who has more than a 25% ownership interest in the reporting company. So it's a fairly straightforward definition of beneficial owner.
Simon, I think what you just said is pretty interesting. I think a lot of people are getting tripped up on that. Sorry, Mohammed, for jumping in here. But, it's easy to say I own 25%, therefore I have to be a beneficial owner. But what you just pointed out is a real big issue, that people don't realize that the president of the company, if he or she doesn't own 25%, but because they control the business, in a sense, they're considered an owner, right? And I think, that's really important for people to hear what you just said, because I think that's something a lot of people are a little confused about.
Thank you, Dan. So, Dan, can you please shed some light on this recent ruling on Alabama and how is this causing more confusion?
Sure. So under the cover of darkness at about 6 p.m. on a Friday afternoon, the courts in Alabama ruled in favor of a very, and I look at it this way, but maybe I'm wrong because I'm not a lawyer, but a very narrow case that was brought on behalf of small business owners that they basically said the court ruled that the BOI was, or the CTA rather, was unconstitutional. And as a result, BOI reporting was not needed to be done. And I think that happened like at 6 p.m. or 6:30 on a Friday evening. And so between like 6:30 p.m. on a Friday evening and let's say 5 p.m. the following Saturday, a lot of firms out there were putting out missives saying, hey, this thing's unconstitutional, full stop. And then literally on Monday morning, you had a number of large law firms come out and say, wait, we've read the ruling. The ruling only applies to the plaintiffs in the case. As such, everybody who was thinking of full stop, turn the car back on because you got to get going and make these filing requirements. Now, there is some belief that other lawsuits will be put in place or I don't know, filed against this the CTA. But for now, Alabama is the only one that has been ruled that the law is unconstitutional. But then again, it doesn't really affect anybody than the folks that were the plaintiffs in the case. And I think that's pretty important for people to realize. Also, the DOJ came out and said, we're going to appeal this verdict. And I'm not 100% sure how long that's going to take, but most likely that's going to take a while. So either way, if you don't live in Alabama and aren't a plaintiff of the direct plaintiff of the case, then I think you should think about filing your BOI. I mean, I don't know, Simon and Matt, you guys have looked at this, I know, pretty extensively. You sent out some really good material on it. Did I summarize that right, or did I miss anything there?
No, I think you caught all the
No, absolutely. Yeah, I think certainly, these rules might be under attack over the next, years. But for now, I think the safe approach is to certainly file and comply with the rules for the time being, because it doesn't appear that FinCEN will go easy on anyone because of the Alabama decision who hasn't complied with the rules.
I mean, the other thing to think about, I think, in regards to this is that, the penalties are extremely high, and more importantly, they're a pain in the neck to deal with. So the cost of filing, whether you use somebody like us or somebody else, is relatively inexpensive. It's a good hedge, I think, against the potential for the fine. And also, a lot of the information that is being provided is information that the IRS already has, and other regulatory bodies potentially already have. So it's not like I don't think it is a bit of an onerous process, but it's not something that is worth sort of waiting to see what the courts do, in our opinion.
Okay, thank you.
And the information is confidential, as far as I understand, right?
Right.
It's not publicly available.
Right. Yeah, that's a good point actually too. There has been, FinCEN has put out a lot of material on this, basically saying that it's only going to be allowed for, I think initially for intergovernmental information sharing. There is some thought that the banks might be able to get access to it at some point, but most of the banks already have this information. They've been saying that, it's not just one of these things where you can call up FinCEN, if you're a DEA agent and get the information. It's more this, they're putting processes in place to ensure that the data is secure as well as not public. And so that, there is a sort of wall around the data to make sure that it's protected, so to speak.
And the CTA only applies to the companies incorporated in the US, or also applies to the companies incorporated outside the US also?
So it would only be applicable to, we've fielded this question actually a little bit before. Foreign entities, as a rule, would not be subject to FinCEN. However, foreign reporting companies would. Those companies are companies that have registered to do business with a state, which is, in our experience, relatively uncommon. I would say that unless you, and that registered to do business at the state, which pretty self-explanatory, you go to the state of Delaware and say, or California, or anyone that has an authority to do business, it would only be if they actually filed with that state Secretary of State. That would be the only time that they would have to file these beneficial reports, but otherwise they are not covered by FINCEN.
Yeah, my sense is, and I'm just guessing, not that I did a lot of due diligence here, but my sense is the powers that be felt like the FATCA rules, provided reporting on U.S. beneficial owners of non-U.S. companies.
Right.
So my sense is they didn't feel like they needed to extend FinCEN to non-U.S. entities that weren't authorized to do business, to Matt's point, in the U.S.
Yeah, no, I think that's a good point, Simon. Although I don't know, I'm not sure anyone had any thought when they decided to put this rule together, anyone in Congress. But that's a whole nother, that's a different webinar, I guess. But you're 100% right, yeah, what you're saying, I'm sure. That's what sort of what it comes out as. Huh?
So, Dan, would you like to tell us the deadlines for these reports?
Well, yeah, I mean, I think Matt covered this pretty well in the beginning, but the real issue here is, look, if you've started your company after January 1st, 2024, you've got 90 days to file. If the company was launched before December 31st, 2023 at midnight, you have up to a year to file. And then the bigger issue, though, is I think that coming in 2025, companies will have to file within 30 days of launching. And as Matt pointed out, there's this issue regarding company applicant. And I know that some of the law firms that we've been talking to, and they don't really feel so comfortable serving as company applicant. Our firm does that work, and others do it as well. But I think that that's another issue that people really need to pay attention to, that there is this other sort of piece to the puzzle that begins or is exposed when new entities are launched. And then, of course, the other thing that sort of Matt touched on, which I think is really important for people to pay attention to, is that if there is some sort of change in the list of things that are defined as change to an entity and their beneficial owners, needs to be reported within 30 days of that change occurring. And the list of those items starts with, if you move one office down from suite 410 to suite 412, you got to tell them. If obviously if a partner dies or moves on or something, that sort of makes sense. But if the beneficial owner, and Matt, I'm pretty sure I'm right with this one, but if the beneficial owner moves, right? So I live in Parkland, Florida. If I move to Coral Springs, Florida, I've got to update that as well. I don't necessarily have to update my driver's license or my passport, but definitely the address. So, I mean, there's these weird little things that people need to pay attention to, that even though in theory it's a one and done kind of filing, there are situations where it's a one and could be multiple times done, So important to pay attention to those things.
I have and just sorry, Mohammed, for the company applicant, unfortunately, and again, we fielded this question in the past, it's not up to the company or even us to decide who that company applicant is. It's whoever filed for that entity. So if Rivalus Wahab, for example, formed the entity, it would have to be us that file. We could not have ANC do that, even though they will be handling the beneficial ownership reporting. We would have to be responsible for the company applicant. If you formed the entity by yourself, then you would be the company applicant. Right. But again, if someone, just to emphasize, if another firm or another person or another entity was primarily responsible for handling it, that would be the company applicant.
So this is a question for everyone, right? In this, obviously these rules are new. Everyone is trying to help their clients, but who primarily are involved in the guarding the clients and filing those reporting or BOI filings. My question is more on the law firm side, compliance side, or accounting firm side. Who do you think are best suited for this? Our approach at our firm level was that because we're not legally, we don't have a law attorneys here, we're not providing legal services, we should stay away from this. Where do you see that, which type of professional firms are helping the clients and which are best suited for them? Matt?
Yeah, I can jump in here, Mohammed. I think the law firms, because we're on, if it's the law firms setting up the entities and we understand who the initial beneficial owners are because we're working closely with the client, I think in an ideal world, it would be the law firm that would file the initial BOI. But I think the accounting firms, especially on the fund side, are generally, or the fund administrators, I should say, are generally in the best position to know the fluctuating beneficial ownership of pooled investment vehicles. So I think ideally, at least closest to the ground. I think frankly though, it's just a manpower issue because as Dan knows, it just takes a lot of time and people to handle all these filings. And I'm not sure we don't have the manpower to do it for every client, unless we were to double or triple maybe. So I think it's that has been an issue for us. So I can tell you the approach that we've taken. We've been very proactive in informing the clients of these requirements when we file the entities, and trying to be as helpful as we can in terms of answering any initial questions. But we've partnered with other firms, including Dan's firm, to outsource the filings in case the client doesn't feel comfortable filing the beneficial ownership reports themselves, just given the amount of time and effort involved in conducting the filings.
And as a quick note, and I think Simon might have alluded to this, it's important to keep track of the limited partners' ownership of the fund, because if they are, for example, a 15% owner, they will not have to be reported under FINCEN. But if they up their investment to past 25%, 30%, then they will have to report as a beneficial owner. And again, as Simon mentioned, the administrator will have to keep tabs on that. Anyone kind of making sure the reporting is being conducted in the right way, will have to keep tabs on that. Just as an aside.
Right. Dan, what's your insight? Right? Which firms are helping the client?
Well, I mean, look, we want to file on behalf of everybody, so we'll take all your business, quite frankly, and with smiles. But I think that the reality is that the AICPA, Mohammed, as you know, basically came out with Aon back in the fall and said it's not a good idea for accounting firms to make the filings. So we're seeing a lot of accounting firms send folks our way for that. As Simon alluded to, it's a process that perhaps from a manpower issue, but also from an economic issue, it doesn't make sense for clients to use their law firms. And so we're seeing that a lot of corporate services firms like ours are doing that work. We have heard that some of the administrators are shying away from doing the work because they feel like there's a liability issue. But I do think there's a couple of the administrators that are doing it. So I think it really depends, quite honestly. And to Simon and Matt's point, I mean, this is, in some cases, this is sort of a one and done kind of situation. But in other cases, as Matt, pointed out, if the investor or the LP goes over a certain number, then an update has to be filed. And people need to pay attention to that. And quite frankly, in the fund scenario, the best person to have that information obviously is going to be the admin. And then perhaps it's up to the IM to sort of bring it to another person's organization to update the filing. But for the most part, we're seeing professional service firms like yours hand them off to corporate services firms like ours.
Got it. Thank you. No, that was very important for listeners or the managers who are listening our webinar, that way they should reach out. Yes, they could definitely reach out to the law firm, the accounting firm, but probably I think ultimately, as you said, that corporate services needs to come in and help them to find those reports. Just to give overview right before we go to the reports, Matt, just give them the idea to the listeners that how steep these fines are if they don't file things on time. I think
I'll take the fines.
In terms of fines, what are the potential penalties?
yes.
Yeah.
I know in New York, I saw at some point, I think it's that you accrue at $500 a day if you're delayed on the filings. I don't recall on the FinCEN side what if they've identified any particular fines. I don't recall.
They have. So I don't know if Dan maybe should, but typically it results in a daily. It can result in a daily $500 fine up to a maximum of $10,000 and 2 years imprisonment. Whether those will be enforced, we'll see. But the existence of these penalties do mean that they at least Congress has provided teeth for enforcement of these rules.
Right.
Thank you. And that was a good for at least for fund manager point of view to identify risk reward right analysis for them, right? Whether it's better for them to pay some fee to make the filings rather than getting the jail time or the fine. Okay, so Dan, would you please jump on this, the annual reports, or I think Simon, you can jump in on those New York reporting. Correct.
Yeah. I'm not. I apologize. I'm not an expert and don't have a lot of information yet on New York. We've been focused primarily on the federal ruling. But I can tell you that there is no annual reporting requirement once it's done on the federal side with FinCEN. However, the update is the issue, right? So the update could be annually or could be every 30 days, depending on how much activity there is in the entity. I'm not sure what the rules are with New York yet. I know it's sort of a little bit fluid in New York because there was an expectation it was going to start in 25. Now it's going to be 26, and perhaps that could change again. But it's not an area of my expertise.
Yeah, in New York, that's one differentiating factor from the federal rules is they're not requiring real time within 30 days updates when there's material changes. New York just requires an annual update after the first filing has been conducted.
Thank you. Okay, let's go to the next. Who needs to complete the BOI filing, right? So would you like Matt jump in and help us here?
Sure. So who needs to complete it is, as Simon addressed previously, all beneficial owners, and as also addressed previously, beneficial owners is a somewhat more expansive definition than just the person who owns the company. That is anyone who exerts substantial control over the company. That would be the manager of the general partner. That would be the general partner and whoever is in charge of, again, the manager, the general partner of the fund that's reporting. Really anyone who is deemed to exert substantial control, which, form over substance, if they are exerting control but don't have the position. We don't recommend that, but they look to the substance over the form in order to decide who's exerting substantial control, as well as, again, anyone who owns 25% or more of the entity, beneficial ownership. That means LPs, that means the members, that means the managing members, whoever owns 25% or more. All entities needs, the entity itself is also, unless it falls within one of those exemptions, needs to report information about itself, such as the slide says, the name of the entity, the tax ID, the address. So there's, again, just to kind of emphasize, there's two. The entity itself needs to report, as well as the beneficial owners need to report. And so just to make sure that people don't conflate that, there is an entity reporting as well as beneficial owner reporting. The owners, the names of the owners have to be reported, the name of the entity, tax ID, the principal place of business of the entity, as well as the residential address and contact information of the owners, which includes typically the telephone number and I believe the email address in certain cases. And all beneficial owners will need to, as the slide says, report the valid passport or driver's license, U.S. resident, or if they're a foreign national, need to provide a PDF of the valid passport. And if they are foreign, they still need to provide the address, even address of their residence in their nation of residence. It's not a U.S. address. It would be the address of where they live abroad. As well as, I'm not sure if the slide kind of addresses this, but company applicants as well will also need to report this. So those company applicants are those that only need to be reported if the entity was created on or after January 1st, 2024, and all information will need to be reported for that company applicant, except for the residential address for certain types of applicants, such as the paralegal or lawyer release or was the company applicant. They can report the business address and not their residential address, just as an aside. Yeah.
No, thank you. That's very helpful.
So can I just say one thing? I mean, this is what, if you go back to that slide for a minute, you don't have to, but this is what makes Congress so interesting, right? They want a company applicant, but they don't want the information about the company applicant's information that they want about the beneficial owner, right? That's pretty funny if you think about it. And then if you read the rule, I mean, you have it right here, which is exactly how it comes out. It's got to be a valid passport or a valid driver's license. Why did they think that anyone would provide an invalid driver's license or an invalid passport? I mean, this is the mind of Congress that we're dealing with, people. And so I think it's pretty funny that this is where their head was at when they were putting this together, or their heads were at when they were doing it. But it's just something I think that we laugh about every time we do a BOI, because in our intake form it says you need a valid passport, and 9 out of 10 times when someone comes back to us, they say, do you think we would provide an invalid one? Right? So, or expired document. I mean, it's just funny to me. Anyway, sorry, there's a little levity in a serious subject, I guess.
Sure. Okay, so obviously, right, so I think we're all concerned about the compliance and the penalties, and because our economies, international transactions are increasing and cross-border transactions happening more. So all these factors are having an impact on businesses, right? So it's not only that impact for LLC. I believe that it would also have an impact on self-employed individuals also, right? So Simon, please tell us here, right, how it can impact self-employed individuals in addition to the partnerships here.
How it can impact self-employed individuals?
Yes.
Yeah, so certainly there's no exemption for companies that are, owned just by one individual, or So, you know, regardless of whether a company is beneficially owned by one person, you know, an LLC would be regarded as a disregard, you know, would, from a tax perspective, a single member LLC would be a disregarded entity, but would still have to report, you know, beneficial ownership. So, so I don't see there being any exemption for solely owned companies. And certainly, you know, both under the federal rules and in New York, partnerships and LLCs have to report beneficial ownership.
So it's not for an individual who's doing a business. It is if that individual is having a disregarded entity has to file the BOI.
Right, right. Any entity that's been incorporated or formed in any state, you know, regardless of the number of owners of that entity, you know, has to conduct these filings.
Okay.
You know, unless, of course, they're in one of the exempted categories,
Okay.
which Matt touched on.
Yeah.
Okay. So let's go to the first polling questions. It's been a while, right? Yeah. So let me launch this. This is the question we have. And we go to the polls. Launch the first questions.
What happens if these people all fail? Does that mean that we're doing a bad job? There's a lot of pressure over here. Matt, specifically for you.
I think probably we might not cover this polling question, but they will still get the CPE certificate as long as they are attempting listening the conversation. So let me close this. So based on my understanding, it is 60 days. I'm not sure if Matt concur with me or not. No?
Unfortunately, I do not. It is 30 days.
30 days? Okay.
Yeah.
Thank you. See, I also don't know. Okay, let's go to the next one. Next screen, sorry. We have already covered here. I think there is no reason to spend more time here, but I just want to ask one question here. Is there any difference between the New York law and the CTA under the federal law regarding the beneficial owner, or same? I think, Simon, you might have touched that.
Yeah, it is the same. The same information needs to be reported, yeah, on both forms.
Okay, and the definition is also the same.
Yes. Mm-hmm. Yeah, it is.
The only thing the one thing you want to keep in mind is Social Security numbers for individuals are not required, right? So I think there was some concern about that, and people were a little nervous about, using, especially if they're using a third-party organization to do it, that they would have to transmit Social Security numbers. So, but that is something that is not required to be filed when you make the filing.
So then, my question to you is, Dan, if there's no Social Security number required, people can change the names too, right? Or they might use abbreviations or nicknames on the reporting. How the regulators at the receiver and agencies will identify?
So we have not experienced this yet, but we're expecting to, that if for example, I decide to get married and I change my last name from Strackman to Smith, but I don't have my updated passport with my new name, there is a potential that if we put in, Smith and the passport says Strackman, that they could get kicked out and be, you could have to update the report. But so our understanding in talking to FinCEN is that the names, first and last, specifically need to match the names first and last on the passport or on the driver's license. But there is, yes, and in the event that I did get married after I filed the document and I did change, or excuse me, I did make the filing and I did change my name and my document was updated, then I would have to make an updated filing with FinCEN for the BOI. Yes. I know Matt and Simon, is that right? I mean, that's how we're working on it. I think, you know, we've talked to you guys a little bit about it, but you're seeing it the same way, right?
Absolutely. Yeah, I think you want, obviously your full legal name should be on your, your identification documents, and that should be the one that's used, in the filing.
Awesome. Let's jump to the next screen, right? What are the consequences right here we're discussing? So Simon, would you like to touch here to file these New York 801 statement, failure to file?
Yeah, so in New York, my understanding is they can, after 30 days, they could start assessing penalties of $500 a day for delayed filings. And then, the company, if the company has not updated this after 2 years, of being delayed, the company would no longer be in good standing. Yeah, there's other penalties that they can assess as well, but those are the ones that are delineated.
Okay, thank you. Okay, so Matt, would you tell us real reason for this CTA from the Congress, and it's more crimes or like more complex international trades or transactions are causing this requirement, or what they were up to here?
Yeah, certainly this at least the stated purpose of the CTA, and hopefully it results in results, but it's designed to fight anti-money. It's designed to ensure anti-money laundering. It's designed to fight international fraud, and ensure transparency for investors, ensure that investors feel safe, entrusting their hard-earned funds to managers, and generally as well, obviously because the CTA applies not only to private funds but also to all entities. Whoever invests in companies or startup companies, feels safe investing their funds, making sure that no one's going to abscond with them. And as mentioned in the slide, facilitate stronger collaboration between regulators in order to ensure, that they can stamp out illicit financial activities, and ensures a sort of a standard setting, has a sort of standard setting role as well, in order to ensure uniformity of enforcement among, several jurisdictions, which have already, such as the BVI in most countries in the Cayman Islands, most countries in the European Union already have the common reporting standard. This is sort of an effort undertaken jointly with those nations, or at least ensure uniformity across the states, even if it's not ensuring uniformity with the common reporting standard. And as an aside too, just to go back to the previous slide, the penalties for FinCEN, I think we had mentioned the penalties for New York, but the penalties for FinCEN providing false or fraudulent reports or failing to make an initial report, it can result in daily $500 fines for every day that the entity is not compliant, up to a maximum of $10,000, as well as perhaps in more extreme cases, imprisonment up to 2 years. So they have provided teeth to enforce these rules. We'll see whether those teeth will ever be bared, but there is potential for somewhat punitive enforcement of the CTA.
Yeah.
Okay. Thank you. Okay. Next polling question. Let me launch this. So, Matt, what do you think is the right answer? B?
Yes, that would be the right answer.
I passed this time.
Oh, a lot of pressure over here.
That's what I'm here for.
So these are the public disclosures, right? Details also. We are trying to compare CTA and New York LTA here, right? It is pretty obvious, I think. Simon, would you like to shed some light here? Any important thing to mention between them?
The major differences.
Yeah.
Yeah. So, of course, as we've discussed, the New York rules only go into effect beginning in 2026, whereas obviously the federal rules are already in effect. Another major difference in New York is that the rules only apply to LLCs and not corporations or other types of entities. Another nuance is if you're exempt under the New York rules, you have to file a notice of that exemption with New York, whereas that's not the case, as I understand it, at the federal level. If you're exempt, you're exempt. You don't have to notify FinCEN of that exemption. Another difference between New York and the federal rules is that whereas any material change in beneficial ownership or other information that's been provided needs to be disclosed to FinCEN or updated in the BOI report within 30 days. Whereas in New York, it's just on an annual basis if there's been a change at the end of the year.
Thank you.
Yeah.
Another point which was mentioned in one of the questions is that so FinCEN, as Simon already stated, is effective January 1st, 2024. If the entity is formed on or after January 1st, 2024, they have 90 days for the first year in order to comply with that. For New York, starting January 1st, 2026, it will be 30 days. So it's a bit of a harder deadline to comply with it, just as an aside.
Yeah. So that, just to be clear, that's for new entities formed in New York, as I understand it.
That's
After
correct.
2026, you have 30 days. If you were formed in New York or authorized to do business prior to 2026 in New York, then you have for all of 2026
That's right.
to
And
take care of that filing.
Yeah, and that's same with the FinCEN. If the entity was formed before January 1st, 2024, you'll have until, as mentioned before, December 31st, 2024. So 365 days, essentially.
All right.
Awesome. Thank you. So I think probably Simon will take again. I think we have already covered some of the stuff here, but anything if you want to highlight here, Simon, on this?
Yes, certainly. I could see this, discouraging on the margins, discouraging some companies from forming or doing, forming in New York. Obviously, if they're doing business in New York, there's not going to be much of a way for them to avoid this, absent moving out of the state, which this could be the straw that breaks the camel's back, I suppose, for some companies. But yeah, nothing specifically with regard to New York that we haven't already discussed that I would highlight here, Mohammed.
Okay. Let me ask this question, right? So if the company is registered in New York, LLC, sorry, no. So they have to do two separate filing, one for the under the CTA, second would be under New York LTA, or both one filing would cover both?
Yeah, I know at some point during the development of the New York rules, they considered allowing an importation of the federal filing or a submission of the federal filing in New York to be sufficient to cover New York, but they, in the final rules as they were adopted, it is a completely separate filing. Obviously, you're providing virtually identical information, but it's a separate filing. So every company will have to file both. That it, at least if you're a New York LLC, for example, you'll have to file both federally under FinCEN, and you'll have to do the New York filing completely separately, providing basically the exact same information.
Right. Yeah. That could change though, right, Simon? I mean, people have, it seems like, at least what we're hearing is that that's the one thing we're a little bit, because people have been asking us about paying attention to. That could change. It could be that you could, the state could say, if you can show demonstration that you filed with FinCEN and give the receipt, and you can, get away with it kind of thing. But I think it's still a little bit up in the air, right?
So which department of New York is going to accept these filings? Did they create a separate New York Attorney General or some other department in New York State?
It's this. I think it's the Secretary of State.
Yeah, but
Secretary of State.
What's interesting, unlike the federal government, which put out a lot of material on this, the New York Secretary of State and the Assembly, and I guess the governor as well, they've been a little bit quiet about this. They haven't, it's hard to find information about it. Maybe now that they sort of finalized the rule, it's a little bit more easy to come by, but it's sort of a little surprising at how little information they're putting out. And hopefully that'll change as what's it called? As the filing date gets closer, but in theory, it's still what, a year and a half away, right? A little bit more than a year away. So it is a Secretary of State.
So, and these all will be online filings, right? Easy to file.
I don't know about easy to file, but it'll be done. You can do it online, and you can actually do it. You can. I think you can. Well, I guess it'll all be on.
So, Ken, from your point of view, did you have the infrastructure to help the fund managers and all our clients, right? So how did you build that infrastructure for them, obviously?
Yeah, so we built, obviously we've been in business for a long time, and we launched our corporate services practice about 7 years ago. And so it was a natural extension of our corporate services practice to do this work as well. So we built a piece of an application. You don't call it software anymore, I learned, but called EACOV, which is a online portal that we use to track information once we get information through using the Verifile portal. The Verifile is, you guys, Akram, I know you guys know, use Verifile when you communicate with the IRS because it's their tool. So we use that as well. So we've basically automated the intake aspect of the business or of the information for the business. And then we have a team of people here in Coral Springs, Florida, that are doing the work. And we've built an infrastructure around double redundancy to make sure that when information is entered into the FinCEN portal, that someone checks it before it goes to go. And that way we do that. And then we make sure it's correct because that's what we want for everybody, obviously. And then the other thing we do, we have an ongoing monitoring function or service so that people are staying, at least keeping it top of mind that if they have to make a change, that they do it within the time period that's required.
Thank you. So time to have a third polling question. So let me launch. This was an easy question to get the CP, so I think everyone knows the answer should be B. I think that's pretty much is. Before we summarize, right, there's another polling question because we need to ask at least 4 so people can get the CP. So I'm going to launch the 4th one too, so at the same time.
This one, at least we know we didn't fail at.
Okay, so we have few minutes before we conclude the conversation. What, Dan, would you like the listeners to get from this 1-hour discussion? Right? What is the crux of the discussion?
Well, I think the most important thing is that you can't rely on this Alabama ruling that if you don't meet one of the 23 exemptions that Matt and Simon talked about, you have to file this report with FinCEN. You can do it yourself. You can use firms like ours. You can use other firms to do it, but it's something you need to pay attention to. And even though it's April and the deadline for people who launch their firms or organizations or entities, whatever, prior to December 31st, 2023, have a year to do it. The deadline, before you know it, as we all know, time moves quickly, so you have to pay attention to it. And then obviously if you're launching a new business this year, and you have to, this is one of the things you have to ask whoever's forming that company for you about. Say, hey, are you going to get this done as well? Because you need to get that done, and you need to make sure it's done, because the fines are I'm curious to see if anyone goes to jail over not filing, but I'm sure they are going to get fined for not filing. And why would you pay a fine for something that is very reasonably priced to complete? So that's really what I think are the takeaways here.
Matt?
Yeah, absolutely. And just to piggyback off of Dan's point, the exemptions are very narrow. It's going to be very broadly applied to, most funds have at least 2 or 3 entities, and some will have 4 or 5 or 6, depending on the amount of complexity they, or the amount of entities they need for tax purposes or other reasons. And you have to make sure that, again, there's most of those will not fall under exemptions unless you're an SEC registered investment advisor or a registered CPO, registered CTA. If you have any questions about that, always feel free to talk to us. But all those entities will have to report entity information and beneficial ownership information, and also monitor each of those beneficial ownership, especially in the event of the LPs owning more than 25% of the fund or upping their investment. And the deadlines for making those changes are pretty tight, 30 days for FinCEN, and the deadlines for reporting them as well within 90 days after the formation of January 1st are pretty tight. So just something to keep in mind.
Thank you. Simon?
Yeah, no, I would piggyback on those comments to say that the way I read it, funds, especially ones that are launching in the year that they launch, they're likely to report changes in beneficial ownership, maybe on a monthly basis, as frequently as monthly, if, as as new investors come in and as the 25% threshold change in a fund. So yeah, I think especially on launch for smaller managers, it's a significant amount of ongoing compliance and not just a one-time filing that they can forget about, to Dan's point. So yeah, I think, you know, we covered most of the high level today on that front.
So I think from my point of view that most of the people are thinking that these BOI filings are only for GP entities or management companies, but they also apply to the funds too, right? So for this, I think the fund admin and the fund manager need to take more proactive role and make sure whenever the BOI definition kicks in, and they have to file those reports at the federal level and at the state level if they are required. I would thank you again, my wonderful panel, Simon, Matthew, and also Dan, for giving us time and sharing the insight to fund managers and our clients, and look forward to doing more after the tax season. Thank you.
Thanks, Mohammed.
Thank you.
Thanks very much.
Thanks.
Okay.
You guys have a great day.